Hello, good afternoon, ladies and gentlemen, and welcome back to our conference in the afternoon. I have the pleasure to moderate this, and I will start off by introducing the participants. We will have four presentations, and the first one will be about the judicial enforcement of capital markets law in the context of initial public offerings, and it will be presented by Barbara de la Vega Justrivo, who is an associate professor of commercial law at the Universidad Carlos III de Madrid, and where she has also a I3 certificate from the Ministry for Outstanding Research. As all of our presentation, Barbara, of course, has an outstanding publication record, which I will not repeat with any of the five people I will present now. But let me just continue by saying that Barbara has a law degree with a specialization in European law and also European doctorate, apart from various master degrees from international universities. Her areas of specialization are, on the one hand, something we Austrians don't know a lot about, that is maritime law, contracts, insolvency law, and corporate social responsibility. And she's also been working as an experience as a lawyer and as a substitute magistrate and advising the Spanish Ministry in legislation as well. So then after Barbara, we will turn to Piotr Stanislavzins, who is associate professor in financial law at the Faculty of Law and Administration of the University of Opole, and who will be talking to us about the capital market court in Poland, about its risks, but hopefully also about a lot of opportunities such an institution may provide. Piotr is also judge at the regional court in Opole and is founder and chief executive of the Association of Financial Law, Aureos. And then after Piotr, we will turn to Maria. And Maria Domina will tell us about the French Financial Markets Authority and the need for a harmonized approach. And Maria is associate professor at the University of Lorraine in France, holds a postgraduate degree from the University of Manchester and a postgraduate from Strasbourg in her PhD she has done in Strasbourg, France. And she was a visiting researcher at various international institutions, among them the University of Oxford and the MPI in Luxembourg. And she's interested especially in comparative law, financial law, and corporate law. And then last, but of course by no means least, we will turn to sustainability disclosure. Sustainability disclosure and the role of specialized courts in this area. It's a bird's eye view. We're going to get over an institutional problem and its possible solution. And this bird's eye view will be given by two presenters, namely, first of all, by Dr. Alperen Götzlügel, who is an assistant professor in law and finance at the Leibniz Institute for Financial Research, SAFE, in Frankfurt, Germany. And Alperen holds a PhD from the University of Hamburg and a graduate degree from the University of Cambridge, also with various positions, among them at the MPI, but this time in Hamburg, not in Luxembourg. Your research interests, Alperen, include comparative corporate law and governance, capital markets law, and financial regulation. And you will be doing that presentation together with Casimiro Nigro, who is a law and finance assistant professor at the Center for Advanced Studies on the Foundations of Law and Finance at Goethe University, which is the Frankfurt University. Casimiro holds a PhD from Luis Guido Carli in Rome and an LLM from the LSE in London. And Casimiro, you are also a visiting scholar at Bocconi, and your research focuses, if I understand it correctly, on corporate law and governance, particularly as regards takeover regulation, which is a hobby horse of mine, and private equity and venture capital-backed firms, and also obviously securities regulation, which you can't avoid in this field. And before joining academia, Casimiro has been working as off counsel for international law firms, specializing in corporate law. Well, this has been a long introduction for a prominent list of scholars. So I just suggest we delve into it, and I would kindly ask you, Barbara, to please start and give us insights into the judicial enforcement of capital market law in the context of IPOs. The floor is yours, Barbara.
Thank you very much, Mr. Winner. I want to thank the organizers for the kind invitation to participate and for the great effort to hold the conference, not on site in my case, but online. The important thing is we are here, so let's go. Well, judicial enforcement of capital markets legislation in the context of IPOs is a highly topical issue that is constantly evolving. In particular, here, the institutional dimension of the Spanish Supreme Court is considered. I have to point out that this work is still in progress, so I can only raise a few issues. However, the content will be developed further in a forthcoming publication. My contribution deals into the question of how application of capital markets legislation in the context of IPOs is giving rise to new interpretations by Spanish Supreme Court on the role of judges in dealing with incorrect information in the prospectus and the trading of financial instruments. The Spanish perspective is dual. On the one hand, there is a contractual aspect of the problem, and on the other, the one that refers to securities market law in strict sense. The topic was addressed by one of the Supreme Court judges. His name is Jose Vela Torres, at the International Seminar on Social and Corporate Responsibility organized by my university, Universidad Carlos III de Madrid, last November. Undoubtedly, the analysis of the Supreme Court's rulings on important aspects of capital markets legislation allows us to affirm that the institutional dimension of Supreme Court is of transcendental importance in closing the justice gap in investors' protection. It is not exaggeration to say that this issue has, for judicial purposes, revolutionized the mindset of the courts with regard to the approach to contractual consent. In order to analyze the role of the Spanish Supreme Court, this research has been divided in two parts. First, the situation prior to the Markets in Financial Instruments Directive, MiFID I regulations, and the second, the incorporation of MiFID I regulations into Spanish law. All this in order to study the assessment of suitability and the products or services to which MiFID I regulations apply. In application of the aforementioned regulations, 6 judgments have been compiled that constitute Supreme Court case law from 24 to 28. In terms of the assessment, suitability, and appropriateness and reporting to clients, two tests are applied. Under the first test, the suitability test, where the service provided is a service other than investment advice or discretionary portfolio management, and provided that it relates to complex instruments, the financial institution must obtain information on the knowledge and experience in the field of investment in relation to the product or service offered or requested by the clients. Second, as regards to appropriateness test, where the service provided is a service other than investment advice or discretionary portfolio management, and provided that it relates to complex instruments, the financial institution must obtain information on the knowledge and experience in the investment field in relation to the product or service offered or requested by customers. Regarding the assessment service, the Court of Justice of the European Union judgment of 30 May 2023 year, yes, case 6 C 604/11 has declared that a specific contract is not necessary. It is sufficient to offer the client a financial investment product in a personalized manner. Well, here the Spanish Supreme Court has taken a step towards closing the justice gap in investor protection. It is a matter of assigning a relative value to the test. Two sentences are example of this relative value to the test. The first, in 2016 year, the Supreme Court failure to comply with the duty to carry out the test does not in itself determine the nullity of the contract, but allows the presumption of error. Another example is the Supreme Court plenary ruling in 2018, and the Supreme Court state that the practice of suitability test and the signing of the predisposed document on the suitable result of the test does not exempt the entity from the exact fulfillment of its duties of information on the risks. A further issue on which Spanish Supreme Court has established case law on the MiFID regulation is the relevance of lack of information to the client on vitiated consent or error. In this line, some of the rules established by the Supreme Court are: the absence of adequate information does not in itself determine the existence of the defective error, but it does allow it to be presumed. Other rule is that in this type of contract, the firm providing investment services has a duty to inform and to do so sufficiently in advance. Another clear, correct, accurate and sufficient information about the investment product or service and its risks must be provided by the investment firm to the potential non-professional client when promoting or offering the service or product sufficiently in advance of the moment at which consent is given so that the latter can be properly formed. And the last one rule is the failure of the investment services institution to comply with the standard of information on the characteristics of the investments it was offering to its client, and specifically on the circumstances determining the risk. All this means that the client's error is excusable. In addition to the above rules, the Supreme Court has also ruled on public offers of acquisition of shares. This regulation is contained in the directive known for everybody on prospectus when securities are offered to the public or admitted to trading. Also in Articles 25 to 30 bis of Ley de Mercado de Valores, Spanish law, and in the regulation on prospectus to be published when securities are offered to public or admitted to trading on a regulated market. This regulation is not yet implemented by the Supreme Court here in Spain. However, the implementation on the regulation has raised several problems. One of them is the institutional investor problem. In December 2019, the Supreme Court questioned whether prospectus liability protects only retail investors or also qualified investors, and whether a possible source of information outside the prospectus can be taken into account. This is an autonomous concept of union law, and then the Supreme Court asked for preliminary ruling in which it asked two questions: whether it also protects large investors, and if so, whether it can be taken into account the large investors can be informed by other means than the prospectus. And the Court of Justice of the European Union answered in affirmative. The European Court stated in its judgment last June that in the case of a public offer for subscription of shares addressed to both retail investors and qualified investors, the action for liability for information contained in the prospectus does not cover only retail investors, but also qualified investors. And second, the judge may take into consideration that the investor was or should have been aware of the economic situation of the issuer of the public offer for subscription of shares on the basis of his relations with the issuer and outside the prospectus. Now, in the light of the European Court's ruling, the Spanish Supreme Court is due to hand down its pending judgment next week on 16 December. This will be the last step towards closing the justice gap in the investor protection by the Spanish Supreme Court. I hope I have provided an insight into the way in which the courts in Spain are enforcing capital markets legislation in the context of IPOs. Thank you.
using phone. Mr. Martin, the phone. We didn't hear you.
Sure. Sorry about that.
Oh,
Typical one.
okay.
Thank you very much, Barbara, for your presentation of the judicial practice in Spain on IPOs and on MiFID. I suggest we keep our questions. We certainly have, we collect them and do the Q&A session at the end of the 4 presentations. And hence, I suggest we turn immediately to Piotr and to the Capital Market Court in Poland and its risks and opportunities. Piotr, the floor is yours, please.
Thank you very much. Welcome. I'm very happy to take part of the conference. Thank you, our chairman, Marcin Miller, for the nice words on the beginning of our panel. It's nice to see Maria, Altoren, Casimir, and Barbara, of course. And I want to say to Professor Ratton, good job. Thank you for the order and our technical staff that we can take part and all going well. I would like to show the few thoughts, direction about the problem we are Poland a few years. It's the Specialized Court, a capital market court in Poland, because we still having nothing about the court. I think that is a problem about the constitutional law, the financial law, and also commercial and the civil law. But on the first, I would like to introduction to the Polish justice system, show what is background about the court in Poland. So let me show the first. In Poland, right now we have the Polish system based on the ordinary district court and the regional courts and courts of appeal. This is civil and criminal cases. So there is a 90% all the cases in the Poland's justice system. In the other way, we have administrative courts and the Supreme Administrative Court. And this is a cases public authorities versus citizen. This is administrative courts deal with the cases in the field of the financial market, including financial supervision and applied administration procedure. There is an act of 1960. It's not mistake. There is a very old act, and I think this is uncomfortable to use in the market in the financial law and also with the future capital market court. So in this way, we have to use the principle of the 2 instances, the constitutional rule in Poland. And in the organization of the Polish justice system, a few years ago, to start special courts. For example, we have special intellectual property courts, and also we have public procurement special court. And the first experience is very good. This court is quickly, the specialized knowledge, the specialized judgment, and the cases in this court are very, very close to the knowing and the of the citizen, also of the part of this case. The next I hope it's going to be okay. So this is the beginning of our thinking and about our direction in the Poland, because currently work on the court of the capital market in Poland at the beginning. 2 years ago, we have a very good conference in Warsaw, prepared, of course, Professor Radwan and also with the Krzysztof Grabowski. Professor Jastrzębski also take part with this conference, and the conclusion was that maybe in 2 or 3 years in Poland we start with the capital market court. Now we have 3 years. After 3 years, we are still in the same place. We have nothing, and so our fate is Professor Radwan to steal publication and make new scientist articles about the Polish market court. So we still on the science platforms, not on the practice. So we start talking about it in the conferences. So after 3 years, we have a brief mention of the documents called Capital Market Development Strategy in Poland. Is a document who prepare Polish financial authorities and Polish government as the way to the development of the Polish market, capital market in Poland. And this document, something about 100 pages, is only maybe half page about the future capital market court. So I think that everybody in Poland everybody in Poland talk about the future court, but we are still in the same place as 3 years ago, and it's not good perspective for us. So this conference for me, and I hope that for the others participants in Poland, is the occasion to look at experience of other countries, because direction of solution in the Spain, maybe in Austria, in Germany, and the Netherlands is the way which Poland or the Polish regulation will go. I hope we best solution take place to the Poland, and we are prepared for the Polish market. In this, we have a few areas of the problems I see right now from the start and make the capital court for Poland. For example, system of the capital market court, common court versus administrative court. We have to explain the constitutional principle of 2 instances and speed of proceeding. As of course, we have to prepare the special court area of the whole country. I suppose that headquarters will be Warsaw, plus the entire infrastructure for prepare the court. Okay, of course, it's the technical, but it's also very important for the start and the work of this court. Special court only functionally with the ordinary courts. I think that with the not administrative court, not common court, not civil and commercial court, but I think that maybe it's only functional in the ordinary courts, but with high autonomy for the, of course, judge, for the director and president of this court. But I think it's something between common court and administrative court. Is the third way. I suppose it will be the best solution, of course, but it will be in practice to prepare. I hope the discussion will be very, very hot. So I think that something take part from the administrative court, some from common court, it will be the best solution. Of course, I know that the discussion will be very, very hard, because the next area the process of selection judge on the capital market court, organization and the model of operation of the capital market court. Technical aspect is very important, but I think that the most important in this process to prepare the capital market court in Poland is, of course, people, personnel, qualification for judges. Maybe something like mixed financial market practitioners, arbiters, maybe people of science. I'm not sure that will be more people of science or more practicals. I think that the same people from the other way have a good solution. Of course, in Poland, because you know to prepare and build the capital market court, it costs. So discussion will be also about number of judge at the first instance and the second instance. Expectation. This is the constitutional rule. I think that something about 10 judges on the first and something about 5, 6 judges on the second instance is enough. We have our experience that is more people that the decision of the court will be different, and market doesn't like this situation. And of course, we have also look at the supervision of the capital. I suppose that we of decision and not a role. This is the proposition for us. We have problem. One moment. Okay. The next area of our beginning is proceeding before the capital market court. The most important role is the financial market is the function of time and money. So we have to, in the other one way, in the other way, we have to respect a party's right so fair and efficient trial. So we have a few ways. Administrative procedure, I think that's very formalized and it's not work good. Commercial civil procedure, I think that indicates the extension of the market. So I think that the best way will be separate procedure for the capital market court, something like mixed administrative and commercial civil procedure. But of course, it's still project or the direction of my, in my opinion. But never mind, this is separate procedure or the mix. I think that we have to know cases involving consumers because it's not the capital market court, and no cases of crime in the financial market. I think it will be still on the criminal court. And the next area is enforceability and effectiveness on decision in the capital market court. The court will only fulfill its role when the decision will be not only quick, but it will be enforceable and felt. Of course, the inventability of the effects of the settlement, and I think the financial penalties is also personal penalties, ban on practicing the profession or suspension of license. I think it's the all areas I show in the pressure of time. There is a way, direction in the process to prepare and start the capital market court. So let me go to our conclusion. Of course, is my conclusion, not the conclusion general in Poland. As I said, is Professor Radwan also is a leader of the prepared this idea. I think excuse me, Poland is the scope of the capital market court for the capital market, formulates only the first assumption and creates the theoretical foundation. I think the purpose of the capital market court must necessarily arise. For me, is natural. I think it will be cooperate joint work of science, financial market participants, financial supervision, and justice. I think this mix will be good. The time period, I hope, will be 23-25 necessary to create an environment for the capital market court. And the capital market court, in my opinion, will be essential element of the growth and importance of the financial market in Poland. So I think it's all prepared for our conference, our meeting. Of course, it's only a few areas, but I think it's the necessary, and if we choose the best way to the growth and to prepare the capital market court in Poland with the experience of other countries, we should and we have to prepare good solution, good court for the growth of the financial market in Poland. Thank you very much. I apologize for my English, but last few years I don't remember that I used the English for the science conference. Thank you very much.
Thank you very much, Piotr, for your interesting presentation of the plans. I've jotted down a number of questions I may have at a later stage, and I suggest those listening in do the same. So, but now I'd say we turn from the project of a new institution to one institution which already has existed for a considerable time, namely the French AMF. And we will now listen to Maria Domina about the need for a harmonized approach. Please, Maria, the floor is yours.
Thank you very much. Dear colleagues, my name is Maria Domina, and I'm assistant professor in business law at the University of Lorraine. And first of all, I'd like to thank the organizational committee of this conference to invite me here today and to give me an opportunity to present my research on the French Financial Markets Authority. So I will start with my presentation. AMF, it stands for Autorité des Marchés Financiers. So in English, it's French Financial Markets Authority. So for the purposes of simplicity, I will use this abbreviation throughout my presentation. AMF was created by the Financial Security Act of 1st August 2003. It represents a merger of three former authorities, namely Conseil des Marchés Financiers, Commission des Opérations de Bourse, and Conseil de Discipline de la Gestion Financière. The objective of this reform was to simplify the regulatory law landscape by providing financial markets players with a single regulatory, supervisory, and enforcement authority. And I will essentially focus today on the Enforcement Committee, which is a part of the Financial Markets Authority. Let's look at the objectives of the Financial Markets Authority very briefly. So according to the Article L621-1 of the Monetary and Financial Code, the Financial Markets Authority is an independent public authority that shall ensure the protection of savings invested in financial instruments and the assets that are offered to the public or admitted to trading on a regulated market, and no other investments offered to the public. It shall also ensure that investors are informed and that the markets in financial instruments operate smoothly. In order to sorry, I will just move to, yes. In order to restore the confidence of investors after financial scandals Enron and Vivendi, Financial Security Act of 1st August 2003 has changed profoundly the action regime and created Enforcement Committee, which is a part of the Financial Markets Authority and whose only function is to rule on the breaches of financial markets law. Enforcement Committee can impose two different sanctions, disciplinary and administrative, on three different groups of persons: financial markets professionals, their employees, and any other person that commits the breach of financial markets rules. So let's look at the duality of sanctions. First of all, Enforcement Committee can impose disciplinary sanctions on those professionals that are supervised by the IMF and on individuals under their authority or acting on their behalf for any breach of their professional obligations. Secondly, administrative sanctions can be imposed on any natural or legal person, regardless of their activity, who has committed or attempted to commit a breach of the financial markets normative rules or any other breach that could possibly undermine investor protection or the smooth operation of the market. These normative rules concern European regulations, European Union law, national laws, and professional rules approved by the Financial Markets Authority. Now, looking at the duality of the sanctions that can be imposed on three different groups of people, we can confirm that the activity of IMF Enforcement Committee has a quasi-judicial nature, meaning that administrative authority can also exercise judiciary function. According to the French Constitutional Council, this is not contrary to the principle of separation of powers, so separation between judiciary and administrative powers. The principle of separation of powers does not oppose the granting of sanction and power to an administrative authority subject to two conditions. First of all, the authority must not be able to impose penalties that involve deprivation of liberty. Secondly, the exercise of the power to sanction must be accompanied by legal measures that safeguard constitutionally guaranteed rights and freedoms. Subsequently, in a further decision of the Constitutional Council that was confirmed and endorsed by the Council of State, there was a principle set forth according to which the accumulation of procedure that could lead to accumulation of administrative and criminal sanctions is allowed and does not fall under the ne bis in idem rule because they are sanctions of a different nature. So we have looked with you briefly at the duality of the sanctions that can be imposed by the IMF Enforcement Committee on three different groups of people. Let's now look with you at the duality of appeal. The decision of the IMF Enforcement Committee can be appealed in two different ways. First of all, they can be appealed to the Council of State with regard to the decision that sanctions the professionals subject to the supervision by the IMF and individuals under their authority or acting on their behalf. Secondly, the decision of the IMF Enforcement Committee can be appealed to the Paris Court of Appeal for appeals lodged by any other person. The decision of the Paris Court of Appeal may be then further appealed to the Court of Cassation or Supreme Court. As you can understand, in the first case, whereby the decision are appealed to the Council of State, there is no possibility to firstly submit an appeal to the Court of Appeal, which is a second part of the French judiciary order. To illustrate the duality of appeal, I'd like to present you a very recent case decision. In its decision of 24 September 2020, IMF Enforcement Committee imposed a fine of 10,000 euro and a reprimand on a fund management company, as well as 100,000 euro fine and a 5-year ban on practicing the profession on the executive of this fund management company. Why? Because there was a failure to comply with the professional obligations. So in total, there were 6 breaches of organizational rules and rules of conduct. While the proceedings were still pending before the IMF Enforcement Committee, the board of the Financial Markets Authority has decided to withdraw the authorization of the fund management company on the grounds that it no longer complied with the conditions required for authorization as a fund management company. The executive of this fund management company filed a petition for interim relief against the decision before the Council of State, which was rejected on the 10th of November 2020. This decision highlights the fact that the IMF Enforcement Committee can impose simultaneously different sanctions: administrative, such as withdrawal of a fund manager's authorization, and financial ones. This duality of sanction and duality of sorry, there is a problem with yes. So this duality of sanctions and duality of appeal presents several difficulties, in my opinion. To begin with, the duality of appeal may lead to the conflicts of case law between the Court de Cassation, Supreme Court, and the Council of State. For example, historically, the Council of State has considered that in the event of a price manipulation by a trader, the bank is presumed to be liable unless it proves that it has implemented necessary measures to prevent the breach of regulatory law rules by its employees. This line of reasoning was upheld in numerous decisions. However, in 2020, in the Morgan Stanley case, the Paris Court of Appeal rejected this argument in the case involving a foreign bank. The duality of appeal also poses several questions as regards the doctrine of the Financial Markets Authority and more generally the doctrine of French financial markets law. We suggest that the harmonization is needed regarding the liability of the financial institutions for the breaches of regulatory law rules committed by their employees, both in terms of substantive and procedural law aspects. This harmonized doctrinal approach shall be binding on all national bodies empowered to impose regulatory law sanctions, which means IMF Enforcement Committee, Paris Court of Appeal, Court of Cassation or Supreme Court, and Council of State, who will then apply all the same approach. In addition, the duality of appeal can also lead to unequal treatment of cases, since for identical facts, a professional and a non-professional will be judged by 2 different courts from 2 different legal orders. Non-professionals will have an advantage over professionals who do not have access to a second level of judiciary order, Court of Appeal. The appeals are made directly to the Council of State, whose decision cannot be appealed any further within the French judiciary system. This difference in the treatment between professional and non-professionals at the stage of appeal against the decision of the IMF Enforcement Committee is particularly prejudicial to the equal treatment of the various parties involved. Further, there is this duality of appeal and duality of sanctions may lead to the divergence in the views between the IMF Enforcement Committee and national courts. The latest case law of the Paris Court of Appeal shows that it's inclined to overturn fully or in part the decision of the IMF Enforcement Committee. The Paris Court of Appeal is also more sensitive to European law and the need to refer the matter to the European Court of Justice. For example, on October 14th, 2020, in the decision that was given by the Commercial Chamber of the Supreme Court, Marie Brizard case, the judgment of the Paris Court of Appeal was overruled and put significant limits on the investigation power of the Financial Markets Authority. However, in the decision of the Supreme Court on 4 November 2020, so less than a month after the first decision, in the AB Science case, the Supreme Court has overruled the judgment of the Paris Court of Appeal and extended the investigative powers of the Financial Markets Authority. So, to conclude, despite the extensive regulation of the Financial Markets Authority and its Enforcement Committee, many questions related to its doctrinal approach remain unanswered. Different decisions of the Enforcement Committee can be appealed in different ways. The different views of the Financial Markets Authority and the courts on the matter of substantive and procedural law do not allow to discern any general approach. All of this issue call for the need to harmonize the approach of the Financial Markets Authority. Now, at this stage of my research, I am more inclined to propose the need to introduce a specialized commercial tribunal that will only deal with financial law matters and not proceed by the harmonization of the activity of the Financial Markets Authority, because it will not allow us to provide an equal treatment to all professionals, employees, and any other legal person involved in a financial law case. So I thank you very much for your attention, and if you have any questions, I will be more than happy to answer them.
Thanks a lot, Maria, for this clear presentation on the diverging problems of diverging possibility of appeal. I can tell you I face as chairman of the Austrian Takeover Commission in Austria precisely the same problem, that some of my decisions go to one institution in appeal and others to another one, and that doesn't make life really easier. I am certain that we will have questions for you at a later stage, but I suggest we now come to our last presentation. Now we look at sustainability disclosure and the role of specialized courts in that disclosure. Well, Alper and Casimiro, whoever of you wants to start, he has the floor, please.
Thank you very much. I will be presenting. So it was nice to hear the perspectives from Spain, Poland, and France. Now we are gonna speak on more pan-European basis. It is very much a work in progress, so any feedback or comment is welcome. As you may notice, there is a slight change in the title, but the content is more or less the same. Let me start with an outline of the project. I will explain each of them in more detail in a minute, but this is an overview of our planned paper, at least. As you may know, sustainability disclosure in the EU is on the rise. Courts have obviously an important role to play in enforcing these disclosure requirements. But our impression or our thought is that courts have generally found it difficult to enforce disclosure requirements, and difficulties will be only confounded in the context of sustainability disclosures. We also think that generalist courts are a part of the problem. Not only historically, they have often fallen short of understanding the complexity of cases, but are now, with this disclosure, sustainability disclosures are now required of uncoding or assessing phenomena that require further knowledge that falls out of their further remit. And in the end, we make a case for a pan-European corporate court as a specialist court to hear cases, among others, related to sustainable EU sustainability disclosure regime. So let me talk a little bit about the rise of sustainability disclosure. As you may know, there is a need and demand for sustainability disclosure by issuers and investment intermediaries. With issuers, we mean companies whose securities are admitted to trading on a regulated market, and investment intermediaries are basically investment firms, asset managers, or institutional investors. So proving receptive to this need and demand, a variety of reporting requirements have been adopted or are forthcoming in the European Union. For companies, there has been the Non-Financial Reporting Directive, which is in force, and there is now the successor Corporate Sustainability Reporting Directive, which is now in the proposal phase, but will become law in the coming years. So for issuers, these are the relevant EU legislation. Under this directive, the information required to be disclosed pertains to both the effect of climate change on the company, so the climate risks for the companies, and also the impact of the company on the environment. So this is called the double materiality requirement. For investment intermediaries, there is also a complex legislation for disclosure, which is the Sustainable Finance Disclosure Regulation, which is already in force. It requires the disclosure to the ultimate beneficiaries, to ultimate investors, of information on the sustainability risks and the principal adverse impacts on the sustainability factors during the investment decision and processes. This is not the end of the story. There is also now the Taxonomy Regulation, which is already in force and will be further developed by the Commission in delegated acts. It extends disclosure requirements for both issuers and investment intermediaries. For example, for companies, they are required to disclose how and to what extent their activities are associated with economic activities that qualify as environmentally sustainable under the Taxonomy Regulation. So that was the rise of sustainability disclosure requirements. Now we look at the challenging role of courts. As you know already from your practice or from your academic work, enforcement is the key to ensuring actual and effective information flows within the market. It is not enough to pass legislation requiring some disclosure. The law and finance literature clearly shows that courts are a major part of the enforcement, and also they are poised to play a crucial role in supporting the implementation of policymakers' sustainability-related agenda in the EU. And with this increasing range of sustainability disclosures, cases before courts regarding misleading or inefficient disclosure are likely to grow. So the main question for us is whether the courts will be up to the task of protecting investors and satisfying the need for climate-related information, while conforming the legitimate cases of non-disclosure for issuers and investment intermediaries. So we have a look at the past, and from that look, we have a prediction for the future. As you may know, the difficulties that are associated with the enforcement of disclosure requirements are set in history. In our opinion, European courts have traditionally found it difficult, to say the least, to enforce disclosure requirements effectively, whether laid out in the prospectus or market abuse regime, or contemplated under the regime for the marketing of financial products for investment intermediaries. For example, courts might have taken too lax or too narrow an approach to materiality. And we predict that enforcing sustainability disclosure requirements will be more challenging for the courts. These are the challenges we identify regarding enforcing sustainability disclosure requirements. First, courts, as always, have to navigate the intricacies of technical and complex legal texts. They need to engage in the process of turning vague regulatory provisions into bright line ad hoc rules. As you know, the disclosure requirements have been always a little bit general. They are not really specific. This is the case also for sustainability disclosure requirements. So courts need to really turn these provisions into bright line rules. And also, this is a new challenge, I guess, or an extended challenge. They need to shed light on their constantly changing content by drawing upon the most recent scientific findings regarding climate change. So we like to illustrate the challenge with an example. For example, under this sustainability directives, issuers, companies are required to disclose, among others, physical risks posed by climate change to their operations and assets, and consider, for example, a case where investors demand damages because a material physical risk which had not been disclosed before materialized and caused a drop in the share price. In this case, judges need to analyze whether the physical risk at that time should have been foreseen by the company and therefore disclosed. This in turn requires an understanding and analysis on the part of judges of spatial and temporal climate data, which indicate any physical risk for the company at that time. Granted, there will be simple cases which can be easily remediated by the court. Companies may ignore to disclose basic information that is required, but in most cases, the disclosure, misleading disclosure or insufficient disclosure, it will be more complex. So at the roots of the problem, we asked some questions and try to provide some preliminary answers. We think that ineffective enforcement of disclosure requirements can be a function of a fundamental problem of institutional design. Enforcement powers have generally rested with generalist courts that have consisted of unspecialized judges who found it hard to appreciate the intricacies of disclosure regime. And obviously, analogous problems will likely emerge when it comes to the enforcement of the more complex sustainability-related disclosure requirements we just sketched above. So acknowledging the existence of this problem in turn calls for an inquiry into what the optimal institutional design ultimately should look like. And our proposal is to create a pan-European corporate court as a specialist court that would, among others, deal with sustainability disclosure cases. We say it would deal with sustainability disclosure cases. Obviously, this would not be the only power of the court. There can be some other powers that or some jurisdiction that can be allocated to this European pan-European corporate court, but we concentrate right now on the EU sustainability disclosure regime. This is similar to a proposal by two US prominent scholars, Gilson and Schwartzman. They also argue for creating a European level corporate court. In that case, they focus on regulating private benefits consumption by corporate insiders. This proposal is also complementary to Wales' proposal. As you know, the EU securities regulation is pretty much harmonized, but it is only for substantive rules. The liability regime is a little bit harmonized, but still member states have their own regimes for the liability, private liability. Wales argues for the harmonization of private liability for failures to disclose information under the EU securities regulation. So our proposal would complement, I think, this harmonization of private liability. But it is important to note that by a specialized court, we imply specialized judges. and accompanying facilitative institutional arrangements. Formalistically branding a generalist court as a specialist will not bring about the intended results. I think my Italian colleague can explain better, but this was more or less the case in Italy. Just taking a generalist court and saying them, okay, you are now a specialist court, it will not bring the intended results. So why do we need specialization? First of all, the intricacies of the law indicate alone the need for specialization. There is a large array of new concepts and terms for judges to get familiar with. For example, climate-related risks, transition and physical risk, environmental impact, sustainability risk, sustainability factors. These are the terms that are just we glance from these directives. So judges need to understand these concepts and distinguishing them, and more importantly, the rationale behind the disclosure requirements, because it varies between these. The rationale varies between the rationale behind the disclosure requirements varies. Sorry, and the intended audience also varies. Some are for investors, some are for audience broader than investors. There's also relevant evidence. Two US scholars, again, they look at some complex bankruptcy-related issues and how generalist courts in the US decide on them. And they find that these generalist courts generally err in deciding the complex issues. There is also the other side of this sustainability disclosure requirements. In deciding whether there was an omission or misrepresentation of information, judges will need to follow the external trends analysis and draw on the climate science necessarily, which we think is a colossal effort for a generalist judge to deal with. So what are the benefits of a pan-European specialist court? It will bring significant expertise that will bear on important cases that will also shape market expectations, and it will help also realize the sustainability agenda the policymakers are pushing right now in the EU. A single court will achieve high specialization, and there will be economies of scale. The effort per case will be lower than in a case where there are some specialist courts scattered across the EU. And also these two combined would help achieve speed in closing the pending cases, because the speed is one factor that investors are really caring about. So this specialist court would also achieve speed, and it would also prevent regulatory arbitrage. Different interpretations of and judgments on disclosure requirements in national member states courts will ultimately lead to an unharmonized application of EU law, and will enable market players to benefit from regulatory arbitrage. For example, if you're a company, you can move to another member state where courts are laxer in their application of sustainability disclosures. And it is also in line with the creation of a European single access point for financial and non-financial information disclosed by companies. This is envisaged under the European Capital Markets Union Action Plan. So there will be a European single access point where all the information about companies will be available. So this why not also accompany this single point by a single point court? So let's look at a little bit the design features of a pan-European corporate court. Obviously, there is the issue of how judges gain the necessary expertise in complex legal matters, but we focus on the fact aspect because most sustainability disclosure cases will be fact intensive. So there's the question of how judges gain the necessary expertise in determining the facts as well. And we identify generally two models. We do not prefer one of these models, but we think one of these models can find a lower or higher acceptance among member states. The first model is is when only those with a law degree can serve as judges. This is like the Delaware Court of Chancery, which is one of the most successful examples of a specialized court. If this is the case, then we say the court should be well staffed and resourced, including non-legal experts like climate experts. If not, then the building necessary expertise and knowledge for the specialist judges will take more time, which would decrease the efficiency of litigation and ultimately negate the use of courts as a private enforcement mechanism for the investors. The second model is when non-lawyers can also serve as judges, and this is the case of Netherlands Specialist Corporate Court, which is another successful example. So when in this model, we think relevant experts should be appointed as judges on the sustainability disclosure cases. Again, in the example of the Netherlands Specialist Court, non-legal experts such as accountants and auditors get appointed rotatingly on cases where their expertise is relevant. A similar model can be developed in our context. For example, climate experts can sit as judges when necessary to help other judges rule on the necessary elements of the case. Certain procedure rules can be also necessary for this specialist court to function, such as extensive discovery and pleading rules that help uncover as much information as necessary. We know that this is not really the case in some member states, but the advantage of adopting a pan-European corporate court is that it can have its own procedure rules. And another point is that location should be carefully chosen because it may be an important factor in cultivating the reputation of the court and contributing to its success ultimately. In the end, we also acknowledge some problems with specialized courts. Some say judges become too powerful. I think this is a necessary trade-off we need to make to achieve expertise. Another complaint is expert judges are not independent. This is really the case in Netherlands. These auditors or accountants are generally from the Big Four, which cast a shadow on their independence as judges. We acknowledge that this is a problem, but in the first model, when you have in-house experts that are connected to the court, then you can solve this problem as well. Another problem is that there is no review of facts with specialized courts generally because they are specialized because they only review the facts and some legal questions go to the appeal. Again, this is, we think, a necessary trade-off in return for expertise. I hope I have been clear in sketching our design or our proposal. As I said, this is pretty much a work in progress, so we appreciate any comment or feedback. Thank you very much.
Thank you, Alperen. Thanks, Casimiro, for the presentation of that interesting topic, and I'm sure you will get comments on that one. Now we have ample time for our discussions, 3/4 of an hour, if I see correctly. So I would once again ask you to write those in the audience to write questions in the channel you are using. We will collect these questions and then I will ask them to the presentators. Let me just start briefly by asking Barbara, you've presented that there's quite a considerable number of cases on investor protection. Are they taken in the Supreme Court by a specialized chamber, una sala, or is this just general? Is this the general Supreme? Is this just general competence of all judges? And anyway, would you advocate more specialization, or do you think that the current Spanish system adequately deals with these issues of investor protection cases?
Thank you, Professor Wiener, for the question. In Spain, the Supreme Court has 4 salas. Civil is for civil, and for commercial. For two, the jurisdiction, the material jurisdiction is mercantile, business law, commercial law, and civil law, to both. But only on the top, at the Supreme Court. In first instance, yes, there is specialization, juzgados de lo mercantil, but only on the first step, first instance. And when you go to the Supreme Court, there is one sala de lo, it's called sala de lo civil, it's the name, sala de lo civil, and there are no judges specialization. But I have to say that I know almost all of the judges, and I have to say they are really well prepared in order to fail, in order to know, in order to apply this legislation. And the proof, in my opinion, the proof is Supreme Court. It's going stating case law in this matter. In my opinion, they are really good at this. They wouldn't need more specialization. In my opinion, humility. In my opinion, in Spain.
Thank you very much, Barbara.
Sorry, at Supreme Court. At Supreme Court.
I understand. Okay. If no one wants to jump in on that one, Casimiro, yes, please. Do go ahead.
My question was more about how the enforcement style in Spain is, whether they take into account the real substance of the facts or whether they just approach the litigated matter in a more formalistic way. I mean, there is a huge divide between in few countries you can actually observe that sort of enforcement that you see in the US. And my suspect is that Spain is not really an exception to a more general European trend. So you would see a more formalist approach. But I just would like to have a confirmation because, of course, this is also important for our paper. So.
Yes. Casimiro, of course, is a formalistic approach, of course.
Thanks.
But this is not a bad approach, in my opinion. It's quite, in my opinion, it's quite safe.
Well,
I don't know.
Yes. Well, depends.
I don't know if I understand. I am explaining correctly. I think formalistic avoids risky decisions, in my opinion.
Yes, but I guess Professor Wiener can definitely say much more about that, and I can only add what I've learned in my own experience as a lawyer first, and as a potential academic later on. When it comes to take over law enforcement, if you are too formalistic, basically you just kill investor protection in the creep, because you will actually see many transactions which are designed exactly to circumvent the rules which are supposed to protect investors. And that basically means that formalism is not really the best way to go. Of course, I understand that from a civil law perspective, we are much more used to get the sure thing. So let's apply the law the way it is without wondering whether we actually achieve anything in terms of real investor protection. But well, I would think twice before agreeing on the fact that formalism is the best way to go. But I understand the way you see it, and I would like to know more. So I will definitely keep note of your paper once it's ready, and think
Me too.
to get.
I will think it twice too.
Yeah, well,
I think
I can tell you, I can tell you that when it comes to takeover law, which to some extent really overlaps in terms of, at least when it comes to enforcement of takeover law, it really gives a number of lessons which might help your discussion, because advocating formalism in this context might really backfire. That's my impression. But Professor Wiener was saying something, so I guess.
yes, I just want to say that, of course, formalistic decisions from the point of view of the judge are safe decisions. And that was probably the point Barbara was making. And hence, formalism, and that was said already in the morning, and there's a lot of truth in it. Formalism tends to decline as experience increases, because the more experienced you are, the more comfortable you feel in an area of law, and the more ready you are to take difficult substantive decisions, and the less you want to rely on formalism, which very often is the cheap way out. So I think, and that was said in the morning, and I think that is basically correct. And that, of course, is an argument which brings us to the court organization, to the organization of the court system. If, and of course, that is a big if it is successful, the attempt to get specialized judges into a specialized court, this is not a given, you must achieve that, then there is a certain chance that you will get more substantive decision, which brings us anyway to the questions already, as far as no, I've got one from Paula Del Val, who was presenting in the morning, and she says, I would say the general critic as regards the lack of familiarity with the business background or the context in which decision making takes place is true for Spain. So that is a more critical approach, so to say. But I think you will always, in any legal system, you will encounter judges of all types. It is impossible just to get the best qualified. Anyway, I have a question for Piotr from Andrea Zorzi. Hello to everyone.
Can I say something, Martin, for like a judge for the Barbara? I agree that the formalists kill sometimes protection, but I think that is working in the other way. The formalists also may kill the judge in the make the decision. So please try to look at this problem in the other view. One of the protection, okay, but the formality is also the problem for the process in the mind of the judge. I as a judge also very often have to choose protection or the human rights, and for the other way, formalism. And sometimes it's very difficult to find the third way. So I think that we have to remember that the formalism make and prepare the way two ways for the protection, and also for the judge who in this area of the formalism make decision for the protection.
Okay, can I just add, Piotr, to you, the question by Andrea Zorzi. He says, perhaps I missed it at the beginning, but what claims would be adjudicated by the capital market court? I understand no consumer claims, no crimes, but apart from that, only cases pertaining to listed companies, question mark. And may I just jump on the question and ask, why would you exclude all consumer claims, especially those referring to damages suffered by consumer on the capital market? Why would you think this is not appropriate for the capital market courts?
Thank you. It's a very important question, and I think about many times about this problem. We have to back to my first direction that the background of the prepare and the start capital market court in Poland. At the beginning, I think that we very narrow try to case in this court. So after a few years, when the court will be stronger, I think that will be closer to the consumer, and we try to wider cases, try to the wider case get to the court. So at the beginning only, I think that will be court not for the consumer. And after a few years, when the court start bigger and stronger, sorry, we will think about the cases of the consumer. I am afraid that at the beginning, when we start very wide, for example, corporation, consumer, and the penalty, for example, for crime on the financial market, this court will be at the beginning very slow, and I think that we will not successful. So I think that will be a few level for the starting and for the growing this court. And after a few years, the next level will be wider than the beginning. I think that will be good start for the narrow case. And after a few years, when this project will be, I hope, work good, we will try to get the new cases also with the consumers and also with the, for example, maybe criminal aspect of the financial market.
Mm-hmm.
I'm afraid about the organization field that will be not good background for the starting court.
Okay. Let me just add up. It is actually a question to three of you, namely to Piotr, to Alperen, and to Casimiro. All of you said that you would not just need the institution, you would not just need the court, but you would also need some special procedure, some procedural law which overcomes weaknesses perceived under Polish law, or in your case, Alper and Casimiro, under the legal systems in general. Isn't it dangerous to turn too many screws at the same time, so to say, and try to achieve everything at once? Do you really think that you can do this all say, design it on the desk, on the table, or wouldn't you need more experience, or is it already clear where precisely the problems are so that you can do both at once? So whoever wants to start of the three of you.
Well, I can say something. I mean, I cannot say that we need extra specialized procedures, so to speak, for 100%. Obviously, it needs to be thoroughly taught. But in Europe, for example, in the Parmalat scandal in Italy, the litigation took place in the US rather than in Italy because the US procedural laws were more favorable to investors because of this extensive discovery rules and pleading rules. I mean, by necessity, you have some. I mean, the issuers are here on the dominant position, so to speak, against investors because they have all the material at their disposal, which would help investors to prove their case. So if you do not help investors to recover these materials, then there will be necessarily a gap in terms of investor protection. But I do not say that these rules are without any disadvantage. Obviously, you need to make tough decisions, or there are certainly trade-offs. But I think in the least that investors are disadvantaged if procedure rules do not help them. I mean, I can say only that, but obviously I agree with you also.
One thing. Okay, thanks. So, well, of course, at the theoretical level, there's it's not that easy to think about so many changes at once. So it's easy to think that we can do that when we sit at a table, but at the same time, of course, it will be much harder, much more complicated to implement them when it comes to turn them into practice. At the same time, one thing which cannot be denied is that unlike general litigation, corporate litigation and investor issues related litigation always builds on a huge information asymmetry between those who invest and those who actually take the money, so capital providers and capital seekers. And to the extent that this information asymmetry exists, general rules, general procedural rules actually struggle at achieving their goal. And the reason is obvious. They really, as Alperen already pointed out, they don't allow investor protection to engage. They don't allow investors to engage in that sort of discovery, which is crucial in order to achieve the goal of finding out what actually happened. So, from this perspective, to think about special rules, particularly when it comes to the allocation of burden of proofs among litigants, well, that's something which we could not really do without. But I'm not sure how much we should stress this into the paper, but perhaps it's something which we should somehow just hint at it without getting too much into the discussion. But thanks for the suggestion.
Piotr, you want anything to add, or you're fine?
No, thank you.
Excellent. So this brings me to a point. These different, Maria, these different lines or routes of appeal. I do have that in the Austrian takeover law, because I have generally an appeal to the Supreme Court in most cases, but in administrative sanctions and fines, the appeals go to the administrative courts. And this is structurally very similar to the situation you are facing. It's even worse because it's the case against the same person with appeals in two directions. So, but what I was wondering is, these things do not happen by design. You don't design things that way. Why? How did it happen? What was the development that brought the situation we have today? Why is it that way? I think you could help us with that in order to understand it better.
Yes, of course. If you come back to the duality of appeal, I explained to you previously that there are two possibilities to make an appeal against the decision of the IMF Enforcement Committee. So first of all, you can make an appeal to the Council of State, which is the highest administrative court, the High Administrative Court in France, for the decisions that concern the professionals supervised by the Financial Markets Authority, or the individuals acting on their behalf, so for example, the employees. And second, the possibility to make an appeal is to the Paris Court of Appeal for the appeals that are lodged by any other person. In this situation, I think the main explanation for this is that you have to make difference between the nature of the person that presents a claim. So if it's a person that is a nature or legal person that is in no way concerned by the breach of financial regulation by the entity supervised by Financial Markets Authority, it can make directly an appeal to the Paris Court of Appeal. Whereas when the case concerns the regulated financial institutions, the appeal has to be made directly to the administrative court. So I agree with you that this is an approach that is not very consistent, and that's why it needs to be harmonized. Yeah, so this is my explanation about this.
Thank you. Now, I do have another question from Paula for Alperen and Casimiro. And one thing which is I was wondering about as well, so I love to read that one. If I understood correctly, Paula says you're considering private enforcement. In many jurisdictions, such claims would be rare. Are you also looking at public enforcement, or would public enforcement of the NFRD somehow eventually benefit from an improved court review system? Why do you focus so much on private enforcement, and why do you not say let's just get an authority which does that?
So, Alperen, you want to go?
Well, one reason is very pragmatic, because this conference is about courts, not the public enforcement. So that's one reason. But there is nothing to rule out public enforcement as well. And we do not say private enforcement is better than public enforcement, or vice versa. But when you look at this law and finance literature, this LLSV, if I remember correctly, they argue that what matters is really courts, in the European Union, at least, private enforcement is weak, not because investors do not prefer private enforcement, because it generally takes time, and I think generalist courts maybe are not up to the task, or there are some procedural hurdles, etc. So I think courts, if investors are given a capable body that would handle matters really speedily and with expertise, I think there is no reason why private enforcement would also take off in Europe. But we do not suggest or that private enforcement should be preferred to public enforcement, or vice versa.
So I wanted to add something which, of course, builds on what Alperen already explained. The thing is just that, at least when it comes to Italy, and particularly when it comes to takeover law enforcement, it's not so clear. Of course, conceptually, the divide between public enforcement and private enforcement, it's clear. But at the same time, decision taken by public authorities, such as CONSOB, which is the Italian financial regulator, can be litigated in the courts. And although anecdotal evidence suggests that courts struggle at understanding the litigated matter. So courts don't really understand what the problem that the investors are discussing against CONSOB are, or what the sophisticated investors that appeal the decision by CONSOB are. So from this perspective, I think that having a specialized court which actually can deal with the problems that are being discussed before CONSOB, and with the decision taken by CONSOB when it comes to the enforcement of some specific parts of specific regulations, can also help. It's not that we necessarily have to think about private enforcement, but of course, it should be clear that our focus is on actions brought by investors privately. So, thanks.
Thank you. Paula says, good point. So you've convinced someone. But this is also a question I'd like to address to Piotr similarly, because if I understood you correctly, you said you advocated a mixed system of common or civil courts on the one hand and administrative courts on the other. Am I correct if I say you meant that such a capital markets court should have both the power to hear complaints by private individuals against other privates, and to hear complaints by individuals against the market authority? So both types of cases could be covered?
Yes, I think that will be a good direction about the right procedure before the capital court. I think that will be, for the beginning, the Poland will start with the public cases, will be, of course, more administrative procedure. And the next time and the next level will be procedure going to the direction of the commercial or civil procedure. But I think we will be two parties of the codex of this procedure. One for the corporate, for the FSA, and the other for the consumer on the private case. I think it will be two others. I think it's difficult to start to take in the one part the public and the private aspect of the procedure. I think it's difficult.
Mm-hmm. Thank you. Thank you.
And can I have a question to the Maria?
Yes.
Please.
Maria, thank you for the very interesting speech. As you saw and listened, I'm in Poland. We prepare for the capital market court. So I would like to know how long does the process take in France? You spoke about the sanction. So how long in the France? How long does the process take in France? And for example, in the France, could you security case of the sanction? How it's working in France?
Yes, I actually wanted to talk about that, but then I decreased my presentation due to the time limit. So, for example, in 2020, IMF Enforcement Committee has issued 25 decisions, which represent a slight decrease as compared to the previous years. And this is mainly due to the postponed sessions of the Enforcement Committee because of the COVID-19 pandemic. But it takes the average time is between 1 and 2 years for the enforcement committee to take a decision in the case. But of course, this we do not consider then the further appeal that may be made by a person, for example, to the Council of State or to the Court of Appeal.
It's quick, so, yes, to 1 year. So
this is a timeline.
And for example, on the security, is there an opportunity to security, for example, the sanction between the last decision for the authorities or the court?
Can you repeat, please, your question?
Is the possibility to security the claim of the before the court make the decision between the start and the end? There is possibility to security the claim.
I mean, via preliminary injunction or something similar, no?
Okay.
Yes. Yes. So while, for example, while the decision is pending at the IMF Enforcement Committee, of course, the interested party can apply for interim relief, but it is not sure whether it will be given or no. Yes.
And for example, Barbara, how long in Spain this process about the court?
Which court? First instance.
And all. How long it take?
Many years. I couldn't say a range, but many years. Too much.
Sorry, Piotr, I just wanted to clarify when you ask me what is the duration of the procedure. So here I'm talking about the procedure of IMF Enforcement Committee. Of course, I'm not speaking about procedure. Yes. So of course, in the court, the procedure takes much longer than the Enforcement Committee.
I suppose. I know. Thank you very much.
Okay. All right, so I see nothing in the chat. Maria, did you want to ask a question or?
Yes, I'd like to ask a question to Alperen. So I really enjoyed your presentation, and I wanted to ask you about this specialized court at the level of European Union. So how do you actually see its creation? Would it be something like a European Court of Human Rights? So firstly, the person will need to go through all the judicial procedure in its own country and then appeal to European Court, or how would you propose to do that?
Yeah, thank you for the question. I mean, we must admit that we didn't really think through all the intricacies or all the parts of our proposal, but I would say we didn't imagine something like European Court of Human Rights, where you first go to your national court, then to the European Court, because it basically defeats the purpose, because it takes a long time. So our purpose is to achieve speedy decision, and then in this instance, you would go directly to this specialized court, and I mean, and I think there will be no review of facts in the end. I don't know whether that would be a first instance court, or there would be another appeal court. We didn't think about that, but I think that's a court where investors go directly in the EU when there's a claim arising from an EU law instrument like the directives we just talked about. I hope this this clears out.
If I can follow up on that one, very interesting. I mean, there's huge problems, of course, of European constitutional law on that one. We've seen that in the patent court, where we needed a separate international treaty in order to get that going. I know that this is not the focus of your research. I'm perfectly aware of that. But one question we do have, you enumerated a number of legal instruments of the European Union which such a court should enforce. And the two main instruments which you started were directives. That is, legal instruments which have to be transposed by the member states, and which will be transposed differently in different member states, as experience shows at the end of the day. How does this fit, this decentralized legislation? How does it fit, and how does it fit with centralized enforcement?
Yes, I mean, that's a problem that we are aware, but when you really look at the substantive provisions of these directives, even though they are directives, they do not really give that much of discretion to member states in harmonization. Obviously, these directives need to be transposed into national law, and there can be obviously differences, even though there's not much room for difference, I think. When that is the case, then the court would take into account the national implementation of the directive that the relevant issuer or relevant investment intermediary is subject to. But we don't think that's something that's a big hurdle before the harmonization or specialization of the court, because we think the differences would not be that big, at least in the substantive area.
So this court, sorry, if I may follow up directly on that one. So this court would not be responsible for the tort claim as such, because the tort claim is subject to national law, very different in different countries, but only within a tort claim brought before a national court, only for the preliminary issue of whether the information requirements have been fulfilled.
Yes, that's true. But I mean, you can think of different models, and as I said, we didn't really think through all the possibilities, all the issues that would arise. That's pretty much working in progress, and you are already illuminating the potential issues that we need to address. But that's one model. And another thing that I mean, there are a lot of scholars already arguing for the harmonization of the private liability regime under the EU securities litigation. I mean, there is also some harmonization, but I think in most cases it is up to member states law. I mean, if you manage to harmonize the private liability regime, which is a big step, I think, to admit, then you can also envisage a court where you integrate all the claims together. But if it is not the case, then this court would work like the European Court of Justice with this preliminary inquiry thing, I would say.
Mm-hmm. And the issue, and this goes, by the way, to Alper and Casimiro and Piotr, the issue of regulatory capture, that is the capture, it is easier to capture specialized institutions by interest groups, which may be the issuers in a capital market court, which may be NGOs in a court specialized on in the disclosure of environmental risks. How would you deal with that one? And this goes also, of course, to the other participants. If you want to say something on the danger of regulatory capture in the AMF or in the judicial system, what would your take be on that?
Should I start again? I mean, the regulatory capture is an issue. I think that's an issue we just acknowledge in the sense that judges become too powerful. I mean, they can also be captured by specialized interests if they are the go-to person on a case. But I mean, there's also the other side of this story, because when you look at the Delaware Court of Chancery, the judges, they do not start, mostly judges, they start as practitioners, and after a while they switch to become judge. And this interaction between practice and the bar and the judges actually increases the reputation of the court, because they trust these judges and they know that they know what they are talking about, what they are deciding on. So, I mean, there is an issue of regulatory capture perhaps, but on the other side, maybe if there's close relationship with this plaintiffs, defendants, or the court, then it also contributes in a sense to the reputation of the court and contributes also its success, I would say. But obviously that's a trade-off. I mean, I cannot rule out that there will not be a regulatory capture. I mean, if it is the case, then bad luck, I would say.
Thank you. All right, so I think we are running.
Can I also have a question to the Alper Casimiro?
Yes, please, do go ahead.
Thank you for the presentation. I have two questions about the conclusion. Now in Poland we have problem relationship between the European Court and the Polish Court. So my question is, what will be the relation between the national and the European courts? And the second question is, I think that it's a good idea to the European Court. So it will be something like similar to the court in terms of intellectual property, or something like that. Like I try to find the answer on the question. What kind of the court will be the level European?
Sorry, I didn't get the second part of your question.
This proposition of the European Court will be similar for the court on terms of intellectual property, something like that?
Yes, I mean, it would be, I guess, similar. As I said, there are things need to be developed, but the relationship between national courts and European courts, I guess, would be complementary. I mean, European Court would be obviously the court to the go for the investors to decide on this misleading or insufficient disclosure. But then there needs to be also some damage to decide, which, as Professor Wiener pointed out, needs to be dealt with national court. But it may also be problematic from our side that investors need to go to two courts, which which is problematic for them. But in Netherlands, actually, that's how it works. In Netherlands, they have a specialized corporate court which decides on these fact-intensive issues. And if according to that decision, the investors go to another court for damages, and apparently it didn't really prevent this Netherlands specialized court from being successful. So it is not a big issue if the European court and national courts are complementary rather than substitutes.
Thank you.
All right. Well, I can just say thank you very much for these excellent presentations, for the, I think, fruitful discussion we had afterwards. It was really a pleasure being with you here today and listening to you and talking to you. And I suggest that we'll finish now, and I think we reconvene here at 4:30 for our last panel for today. Thanks again, all of you. Thanks of those of you who've been listening in. And well, let's see each other again at 4:30. Thanks a lot, and bye.